Bienvenidos a todos y a todas a este diálogo con las personas candidatas a jueces y juezas de la Corte Interamericana de Derechos Humanos. Le damos las gracias a las candidatas y candidatos por acompañarnos esta tarde. También agradecemos a quienes están siguiendo el evento en las diferentes plataformas y desde las diferentes partes de las Américas. Para quienes nos siguen en Zoom, les recordamos que pueden activar la opción de traducción simultánea español, inglés o portugués. En la parte inferior de su pantalla encontrarán un icono para habilitar la traducción al idioma que necesiten. Les recordamos que también tenemos la transmisión en el Facebook Live y YouTube de las organizaciones convocantes. Este evento está organizado por CEJIL, la Fundación para el Proceso DPLF, IFEX-ALC, la Redlad, el Programa de Estado de Derecho para Latinoamérica de la Fundación Konrad Adenauer, Open Society Justice Initiative y Robert F. Kennedy Human Rights. Todas nuestras organizaciones comparten desde hace muchos años el firme compromiso de apoyar iniciativas que fortalezcan la capacidad del sistema interamericano de promover y proteger los derechos humanos. Una manera fundamental en la que creemos que podemos llevar a cabo este compromiso es buscando posibles formas de aplicar algunos de los principios y valores que promovemos: transparencia, participación, diversidad, equidad, inclusión.
Equity and inclusion to the processes of electing people in leadership positions in our regional human rights system. Due to timing issues, we will not present the CVs of candidates, but we invite you to read them in the dissemination materials for this event on the social networks of the convening organizations and also on the official OAS website. We are at a key moment for the IACHR before the election of 3 members for the commission of 4 members of the Inter-American Court. We see this dialogue as a small but important contribution to providing greater visibility and engaging more stakeholders in the process. We hope that this effort will be a genuine contribution for choosing the best people to lead a vital human rights institution. As we know, for many victims, the Inter-American Court is one of the first stances which allows them to access to justice for the human rights violations that are committed in our region. The event will be organized as follows. In the first 3 rounds, the questions will be formulated from a series of topics that were shared in advance with the candidates, and each of them has 4 minutes to respond. In each round, the order of panelists will change. The 4th round will consist of 2 questions asked by the audience at the time of registration, and the candidates will have 5 minutes to reply. At the end of the time allotted to answer, your microphone will be muted. We would like to ask panelists to modulate their speed and intonation to facilitate the interpreter's work. So question number 1 that will be moderated by Ursula of the Due Process Foundation. Thank you very much, Helmut. Dear candidates, it is a pleasure to greet you, and I thank you again for participating this afternoon. For this first round, the order of participation is expected to be as follows. We will start with Rodrigo Buderovich, and then Veronica Gomez and Nancy Hernandez. We will follow with Fernanda, and we will conclude with Patricia Perez. So let's ask the first question. The relationship between human rights and the environment has gained special significance in recent pronouncements of the Inter-American Court, quasi-judicial bodies, and special rapporteurs of various supranational human rights systems. The current and future effects of the climate emergency call us to think about more precise standards of respect and guarantee of the right to a healthy environment, the scope of justiciability under the normative framework of the Inter-American system, and its relationship with other rights usually impacted in situations of environmental change. The question is, in what way could the Inter-American Court continue to contribute to the development of specific standards applicable to state obligations to protect, respect, and guarantee the right to a balanced environment? We are going to start with the candidate, Rodrigo Modrovic. Good afternoon. My special greetings to the organizers of this event and to the women and men candidates to the Human Rights Court. The agenda of authorities is increasingly oriented to global issues in environmental matters, not for a different reason. The last General Assembly of the United Nations has stressed the need to respect the planet and people's rights. Last week, the UN Human Rights Council acknowledged that a healthy environmental right is also a human right. In the same spirit, the climate COP26 convention that will convene shortly has called on joining efforts to help people and lives because of climate change. In the Americas, I believe that this topic is especially relevant. The changes in the overall climate are concerning our nations. I understand that the decisions of COP are correspond to this challenge. The Inter-American Charter and the San Salvador Protocol call states to action in terms of environmental development, and the Inter-American Court is also part of this process. The most famous example is a consultative opinion of 23 of 2017. At that time, the court stressed the interdependency relationship between human rights, environment, and sustainable development. In exercising its jurisdiction, the Inter-American Court has recurrently faced the issue of the environment, be it directly or in a reflexive way. And its decisions on indigenous peoples, for instance, has led the court to acknowledge the relationship between protecting environmental rights, the assurance of life, dignity, and cultural identity of indigenous communities. In one of its most recent cases, tried in 2015, the court decided that the respect of indigenous peoples and international environmental rules, and I quote, should be seen as supplementary and not exclusive rights, unquote. It is essential, therefore, I believe, to stress the role that the court has been playing in acknowledging that damages to the environment may, in fact, lead to human rights violations according to the San Jose and the San Salvador Pacts. I see that these contributions illustrate the role that this court has been playing in a progressive interpretation of economic, cultural, and environmental rights expressed in its decisions about Article 26 of the American Convention of Human Rights. It is the revision of a pathway that should be strengthened in the coming years. Thank you. Thank you very much. And now, candidate Veronica Gomez. Thank you very much. First, I'd like to acknowledge the organizations that take part in this event and that have convened it, that strengthen the transparency and the choosing of women and men judges for this court. A few days ago, as has been mentioned, the Human Rights Council of the UN adopted Resolution 4813 that acknowledges the human right to a sustainable environment. In the same session, a report session was created about human rights in the environment. These decisions were adopted in the United Nations, but it is important to stress that they were proposed by OAS member states, amongst other states of the international community, and were also supported by other member states of this organization. So it is, without a doubt, a small but fundamental progress in the progressive development of international right in terms of acknowledging a right which is of a peculiar size. The Inter-American Court has adopted or has taken a few initial steps in acknowledging the right to a healthy environment in its consultative action that has been mentioned, but it is clear that it is only the beginning of a pathway towards developing international human rights that will make this court answer questions and alternatives, as has been mentioned in several realms. The court will have a possibility of galvanizing the commitment of the states of the region, a commitment that they're starting to show for protecting a healthy environment while protecting other fundamental rights that are affected by the climate emergency. This in the light of the voices of the victims and of social movements, which currently include children, because of the scientific evidence of the changes that threaten the balance of our ecosystem. So this is one of the tools used by the victims and by these social movements, as is shown by some recent decisions and others that are being supported around the world. It is therefore a challenge of a global scope before which the court will have to gather tools for protection at a regional level. The court will face the challenge of protecting the environment, social, economic, and cultural rights, the impact of new technologies, and the protection of childhood. All of this in a holistic manner, while interpreting these contributions to international human rights in relation to these new challenges. Thank you very much. Thank you very much, Candidate Gomez. Candidate Hernandez now has the floor. Your microphone is not on. Greetings to all of those who are listening to us this afternoon and to the organizers of this event. It is undoubtful that environmental protection is an imperative for human rights internationally. And it has been said that the International Court, based on its jurisprudence, has created relevant standards. In its consultative opinion number 26, it stresses the interdependence and indivisibility of the environment, human rights, sustainable development, acknowledging that the deleterious effects of climate change affect human beings, and climate change has turned into an existential threat to humankind. The sea level rise that affects millions of people in coastal areas. And currently, there is no international rule that gives juridical protection to people who have been displaced because of climate change. And this affects differently different peoples. The Kiriwati people in the western part of the Pacific Islands is an example of this. There are several islands that have become uninhabitable because access to land and to water supply has become impossible. Because of this world phenomenon, there are no standards regarding this. So there's the possibility of, although there is an exception, this case is far from being an exception. So it is important to adopt minimal standards because these are human rights, including the access to drinking water, which has been declared a fundamental human right, the obligation and responsibility of providing humanitarian protection and health protection to assure non-discrimination, freedom, access to justice, as well as adopting actions to make dignified migration more likely. So the Inter-American Court and its decisions will depend on the cases it hears, but in fact, one of the challenges in terms of the environment that we will face as a region is migration of massive displacement of people for climate reasons. Thank you very much. Thank you very much. Now, candidate Cesar Landa has the floor. I am waiting for the 4 minutes to be started. Thank you very much. Good afternoon. I'd like to greet the organizers, the candidates, and our audience. The human rights model in the region has been evolving according to the changes in the rule of law from an idea of rights to a participation of the state for protecting rights. And most of the national bodies of law have been incorporating this, and there is a consensus for this. And the court, in its dynamic interpretation of the convention, international convention, that is the Stockholm Convention and others, especially the 2030 agenda of the United Nations, has set some precedents and standards regarding the indigenous peoples, the Jansi Axaba community of Paraguay, another one from Suriname, and those could be bettered by establishing a general standard and a specific one. The general one would be to advance in environmental rights, taking into account its coherence and proportionality. So we would have to look into the scope of environmental rights. And there's the Escazú Convention that acknowledged 3 rights: the right to environmental information, right to citizen participation in the decision-making processes and environmental processes, and the right to access to environmental justice, and a special protection to environmental militants should be included. And also international responsibility should be also included because they're complementary sources in environmental law internationally. Thirdly, there would be a control that would be necessary to establish the second standard that is specific is meant to be based on international obligations that is specific in terms of international environmental law. So the protection of victims should be seen not just as subjects of individual rights, but also of collective ones, a reason for which we should apply a standard. And in the case of environmental danger, there is the creation of a damage, and there's also precautionary measures in face of environmental damages. This calls for the adoption of positive measures like a plan for risk management, which would lead to applying the idea of proportionality. Thank you very much. Thank you very much, candidate Landa. And now, Patricia Goldsby, you have the floor.
Thank you very much. I would thank you for the opportunity of being here with all of you. And I would like to congratulate every organization that is contributing to this. I really appreciate this topic. And since we have time restrictions, I'm going to talk about a few points. And some of these points have already been mentioned. As a little bit of context, last week, the Human Rights Council of the United Nations, based on the Sustainable Development Goals or Sustainable Development Agenda 2030, issued information about the environment related to human rights. We need to create collaboration with other states, supervision organizations, civil society, and public policies. Number two, preserving the environment and protecting the environment is important in itself, but it is also important when it comes to other human rights. In this sense, I would like to mention Consulting Opinion 2317, where we see the bodies from the OAS with non-governmental institutions, the academia, and civil society organizations. This tool is very important for its effects and advantages because we can see the interpretation of this court and we can see the legal framework for states to comply with their international obligations. I think these advisory services should be taken into account in the context where we want their opinion. These advisory opinions, well, the court uses prevention mechanisms, which is related to regulating activities and oversight and supervision of decisions related to environmental policies and contingency plans to minimize the possibility of damage. This also has to do with mitigation measures. Finally, I would like to say that these standards were applied according to the ruling. According to Cerqueira and Cabrera, this is a lot of progress. We saw clear rules and clear norms being established, especially when it comes to how to prevent environmental damage related to specific activities. We also see information about different measures related to the complexity of this. This is a very broad field, and we saw different deadlines to minimize impact on the Creole population. There is room for opportunity to make more progress in specific standards, determining what states should take into account between affected rights and duties. For example, in the United Kingdom with the Heathrow Airport and the problems created by it, They concluded that the assessment methodology used by the government was appropriate, with consultations and with other measures. We have something else in the Hearson case, which didn't take so many elements into account. I believe the OAS, which is a body included in human rights bodies, to keep on working on this matter, taking into account something deeper and something more prominent for the environment and for global phenomena of climate change, especially with its impact on the most vulnerable parts of the population. Thank you. Thank you, candidate Patricia Perez Goldberg. Thank you for your answer. We can now go to question number 2, which will be moderated by our colleague Francisco Quintana. Thank you, Ursula. It is a pleasure to be here with you for such an important event. Now, the order for this round is Patricia, Cicerlanda, Veronica, Nancy, and Rodrigo. The work done by the Inter-American Court of Human Rights is extremely important to make sure we have reparation for victims with measures for non-repetition. The court has been making efforts to strengthen compliance with its rulings, for instance, by holding supervisory hearings, arranging expert opinions through amicus curiae for this stage, and by creating a specialized team dedicated to this issue. On some occasions, there's also on-site verification visits. My question is, how do you believe we could make progress in ensuring the deployment of the rulings by the court by these states? Would you propose any changes to improve the efficiency or effectiveness of the court's rulings? Dr. Perez Goldberg, go ahead. Thank you very much. This could be considered the Achilles heel, not only for regional systems, but for human rights systems overall. With the yearly report from 2020, we see 257 cases that are under deployment and 1,231 measures that are under supervision. Of course, reparations could be really broad. So our question should be, how can we make better efforts to improve compliance with these rulings? First, I think we need to highlight the efforts made by some states to make progress in the implementation of mechanisms and tools that make it easier to have intersectorial coordination. As we know, some states, according to hierarchy, have systems to ensure there's compliance with rulings, for example, Mexico, Guatemala, Colombia, Ecuador, Peru, and Uruguay. However, in Mexico, it is possible to hear civil society organizations in this process. The Supreme Court in Chile, for example, agreed that rulings against victims that were no longer in effect should be submitted or subjected to a few steps to make sure that these rulings were complied with. And we need to find a way to do that. According to the records that we've had and we've seen, in this case, rulings were extremely important and were related to justice actors. This is related to rulings and also to the violation of human rights in Peru. And the court, instead of just specifying specific reparations, established parameters through which courts should operate. However, we do see that all over the world, sometimes it is harder to comply with measures that are related to research. In any case, having tools and mechanisms is not enough. We need political will to comply with this. And political will takes place through dialogue, through which we can build trust between these actors, including civil society. This is how we can really foster a culture of compliance. When it comes to the work done by the court, we need resources to do this work. A best practice we saw during the pandemic and which we could keep is having these hearings online, these supervision hearings by state, because this way we can have more people attending it. Whenever we have restrictions on mobility, we could have this option by these judges. This is how we can foster progress with local players and with more people coming together and coming closer to this court and coming closer to the reality of these countries. Thank you. Dr. Lenda, the floor is yours. Thank you. The binding efficacy of the court requires specialized diagnosis when it comes to why it takes a long time to comply with these rulings. In some cases, this could be related to funding, or this could be related to operations, for example, a lack of norms and procedures for compliance, or maybe both. In any case, we need to understand that rulings by the court do not have to do with coercive forces internationally. Its elements are based on normative rulings that were created to protect the victim. So rulings shouldn't just condemn states, but we should really think about how to protect these victims efficiently. So at the end of the day, we want to have supervision to make sure we have compliance with these rulings when they are not complied with. In some cases, we see states paying damages, but they don't comply with non-repetition measures. We need to do both. So complying with these rulings is an obligation by the state, and this should be done in due time because of the matter we're dealing with. We have vulnerable populations whose rights have been violated, so reasonable deadlines should be taken into account to ensure the validity and the efficaciousness of these rulings. So we can't make their case worse with delays. That is why we need internal, ordinary processes, constitutional processes that include constitutionality and conventionality. We need to make sure victims can request compliance with these rulings. Non-repetition measures also mean that these states should change their legislation and change their laws. Courts need not only a norm or a law, but we need to analyze the internal legal order in these states according to procedures, so that we have the norms that we need to have to make sure we ensure these rights, according to Articles 1 and 2 in the Convention. We should also have a schedule related to partial or total non-compliance with these. We need to think about administrative reforms to adapt to the needs and responsibilities related to compliance so that these rulings are truly in effect. Number 3, when countries are late on complying with these rulings, there should be a monitoring plan for these matters. Of course, these events are extremely important for the victims. And when it comes to paying damages, we need to monitor these hearings and we need to monitor if these states are complying with their obligations. This has to do with protecting human rights protectors in this system to make sure rulings by the court are complied with. Thank you. Now I would like to hand it over to Dr. Hernandez. The floor is yours. According to Articles 67 and 68 of our convention, states are committing to complying with rulings by the court in every case. We know these decisions are unappealable. So the Inter-American Court of Human Rights issues these rulings and states need to comply with them. They need to fulfill their obligations in good faith internationally, and among these is the right to ensure compliance. However, what we see in reality is that we have a number of different challenges in this case because we have around 240 cases under supervision. This means around 1,231 reparation measures, as the ones mentioned by the court. And they go beyond paying damages, especially with measures that are more complex and innovative. More efforts are needed to make sure that we have appropriate reparations and to make sure that we're able to make progress in fulfilling these rulings. I believe in a more participative present justice, and that is why I think we should have joint supervision, which has been developed with hearings and local visits or visitations. These initiatives, according to official data offered by the court in its yearly report, had different impacts on different players when it comes to compliance, improving the possibility of dialogue with different representatives of these victims, these different cases, and leading to more dynamic participation of state players as well. This corresponds to more reparations. Something else we could add to the mix is a methodology with criteria for supervision for these cases. For example, Cesar Landa was talking about the regularity and format of supervision, because in actuality, we know that many of these sectors do not have a specific methodology unless we have evidence in the requirements made to the states. For example, last year, we issued 9 decisions for supervision out of 327 cases. So it's around 20%. A standardization of a supervision methodology could give us more indicators and could give us more transparency and equity when dealing with these states. Thank you. Thank you very much. I will now hand it over to Dr. Veronica Gomez. And please speak a little bit more slowly, especially because we have interpretation. Thank you. Rulings and decisions by the Inter-American Court of Human Rights are described by their total focus on reparations, both materially and immaterially. More specifically, we always talk about non-repetition measures. This focus of reparations separate the Inter-American Court of Human Rights from other international panels working with the international protection of human rights. We saw important contributions for the development of international right being created through this. This is how the court was able to prove its commitment to working with human rights and the impact of its violations in this region, but it also led to the deployment of decisions and the obstacles that we need to face. Sometimes these are similar to what we see through our legal authorities internally before we take these proceedings to the Inter-American system. Now, this is a really good question, because based on this experience by this court and in a progressive way, they have adopted and developed tools to make sure there's compliance with their decisions. This progress in what they were able to achieve was really positive, in my opinion. And as Professor Landa was saying, this is a key topic when it comes to follow-up and compliance with participation by the states and by the victims. Now, I believe we can't rely on the assumption that these tools will be in effect, but we should support them and we should delve into them. States should also make an effort because we need legitimate participation from other players in this arena, nationally speaking, in order to create mechanisms for compliance. In this sense, we see best practices for this kind of exchange between the states in a region. We have an institutional focus or an inter-institutional focus through these complex relationships involving the relationships between different bodies in these states. We also have relationships at a federal level for some of these states in this region. Of course, we do see obstacles when it comes to compliance with this. And oftentimes, it is hard to foster dialogue internally in these nations. But what we want to do is to keep on creating stronger tools, the tools that the Inter-American Court of Human Rights has developed. We also want to foster best practices and their exchange between different players in this region. And we want support from political organizations in this institution. As we know, this is support some of these bodies have provided for in a few treaties, and we want to expand this to the Inter-American Committee.
Thank you. And finally, Dr. Mudovic, thank you. First of all, I'd like to praise my fellow candidates. I think that many of you have brought concerns that are common ones, like the statement that supervision would be like a soft spot of the court, a weakness, Achilles heel that would call for dialogue in order to be resolved. And I think that this is the right frame of mind. The Inter-American Court and its electronic portal now records more than 200 cases which are being enforced in terms of rulings. What this shows is that although that the court has highly relevant initiatives for perfecting and implementing its rulings, there is room in terms of efficacy for making progress even further. Article 62.3 of the Human Rights Charter makes the court responsible for enforcing its rulings. So I think that assuring the full implementation of its rulings should be a priority task of this body. In my view, the proposals for perfecting compliance with rulings, with everything that was said before me, can be seen in two ways. Firstly, I think that it is the role of the Inter-American Court also to try and foster the finding of amicable solutions between parties. That is part of rule number 63 of its standards, and also always respecting human rights of the victims. The pathway of a petition in the Inter-American system allows for negotiations, but agreements are still uncommon. There was the 2016 Costa Rican agreement, which played a very important role, or the court played a very important role in this case. And there are other pacts before its ruling. Another possibility is to make agreements between the parties in order to make the implementation of the ruling feasible. In Brazil, the case of paying damages has had an example in Brazil. And I think that always safeguarding the human rights. The court can try to help parties reach agreements with clear procedures that can lead to the making of agreements in different steps of the procedures. Secondly, I think that expanding the efficacy of the court decisions also make it be closer to states, and its authority will be further recognized. The rulings of the court are not restricted to the victims, but go further. Very often, the rulings impose changes in the legal frameworks of states in order to combat the structural features of human rights violations. In order that these measures are efficient, permanent contact channels have to be opened between the court and national authorities and victims. More than inspection, I think that this process calls for dialogue, for a constant exchange of experience between the court and the agencies in the various countries. In order to achieve this goal, it is important to bring the court closer to local realities in order to enforce the implementation of inter-American standards at all levels. Thank you very much. And we will now move to question number 3. That will be led by Liliana Gomboa. Thank you very much. I'd like to start by reiterating a cordial greeting to and our gratitude for joining us. The order of the presentations for this round will be Dr. Hernandez, then Dr. Rodrigo Modrovich, Dr. Veronica Gomez, Dr. Patricia Perez, and lastly, Dr. Cesar Landa. On the other hand, there is a constant need for improving the dissemination of knowledge of the rulings and standards of the Inter-American Court. What do you think should be the role of the Inter-American Court in this regard, and how would you improve the role that the court has played so far in disseminating this jurisprudence? And lastly, what would you suggest so that new audiences could be reached? And I give the floor to Dr. Nancy Hernandez. Thank you very much for your question, Dr. Liliana. The Inter-American Court has a very thorough communication that has been improving with the years, allowing for access to its sessions and also academic activities through all of the technological platforms. And it is to be stressed the role of dissemination by infographics, the search mechanisms, thesaurus, and others. Always trying to have greater dissemination reach with the involvement of young people and non-specialized audience could be considered. I think that we have to come out of our bubble of the Inter-American system. In Learned Hand's words, freedom is alive and it lives in the hearts of people. So we should not forget that an educated population in their rights is the best ally in assuring human rights. But we have to reach out more for schools and universities, giving out courses and training programs by means of agreements with universities and all of the countries that belong to the OAS. But perhaps what would do best justice to disseminating jurisprudence would be that the juridical operating in every country should have access to the court jurisprudence according to themes of topics, the process for integrating this knowledge for jurisprudence search is something to be considered. There is also a summary table that is a project that is now in course. I think that we should look for a way for formalizing this kind of initiative by means of agreements with every actor of the inter-American system so that the jurisprudence of the court can be incorporated. The Supreme Court of Costa Rica makes it available to any other court, this system, should you wish to use it at any time. Thank you very much. Thank you very much, Dr. Hernandez. Now, Dr. Rodrigo Murdovich has the floor. Thank you. From the beginning of my campaign, I always expressed a concern with the little presence of this court in certain countries or regions of our continent. As a result, besides the smaller number of cases presented to the court, this distance leads to non-compliance with human rights treaties and the jurisprudence of this court. I believe that there is a lot of room and opportunities so that the Inter-American Court becomes more present and relevant in different countries all around the Americans and especially the Caribbean. The nations in our hemisphere are marked by great diversity of cultures and legal systems. This reality brings each system their own dilemmas that are inherent to the full fulfillment of human rights. So the court has to take these peculiarities into account. Overcoming these challenges should start with two main lines of actions. The first one is adopting policies for bringing the court closer to states' realities. This means more respect to its precedents and more fulfillment in terms of human rights. So I think that the International Court of Human Rights should more frequently bring about or enforce measures of cooperating with local authorities and holding courses and events in the different countries. Other measures that should be enforced are the holding of extraordinary sessions outside the headquarters, and also promoting more exchange programs with the universities. An important example is the courses for training on the human rights system promoted by the court in some countries over the past few years. It would be interesting to take these courses to places where the court is less present and active. A second line of action would be the effort for the court to disseminate information on its control. I think that lawyers, public administrations, judges should be aware of the precedents of human rights when they're dealing with their own country's rights. So an exchange of experience should be promoted with the legal authorities in different countries. This is a way of disseminating the practice of conventionality control and even more respect to inter-American treaties. The strength of the court rulings should not be limited to the enforcement by the court itself. The efficacy of standards call for its incorporation into the standards of the decision-making levels of every country. I think that all of these measures could be an important step so that the court is recognized by vulnerable groups. And I'd like to stress once more, in places where the work of the court is still not notorious as it should be. Thank you. Thank you very much, Dr. Mudrovich. Dr. Veronica Gomez has the floor. Thank you very much, Liliana. As we all know, the authority of international courts, and especially the human rights courts, depend on their legitimacy before the victims, the civil societies, the human rights institutions and, of course, the states. This calls for special attention to transparency in procedures, the burden of proofs, clarity, the timeliness of rulings, but especially of communication. The improvement in communication of the Inter-American Court calls for genuine contributions to strengthening it as an institution based on the activities of promoting standards to Latin America, all the way to the same activities for promoting these standards in the Caribbean and others. The court has been working silently. The development of its web page was mentioned step by step throughout the years, the development of tools like Perez, of the hearings, of its notebooks. The court has courses that have been developed and tools that have been developed for improving communication. Nevertheless, such development calls for greater support, not on the part of the organization itself only, but also from the countries of the region. It is clear that, first of all, it is essential to assure accessibility to the rulings, not only in Spanish, but also in the other working languages and in the other official languages of the organization, and also the non-official languages that are also spoken in our region. This is essential. And I would also say that it is relevant to think of strategies for enhancing oral dissemination of rulings in the media. We now have tools of this kind, and perhaps we can find ways to reach different populations in different languages, reaching out for all of our Inter-American community by other means of communications that are also that can be also accessible in remote areas in the continent. Now, human rights education, for which we worked for so many years, and that is so well established in some jurisdiction, in others still require a lot of attention in law schools and judicial schools. This is also something that has been mentioned, but that is very important, which is promoting the conventionality control by means of getting to know the standards of the Inter-American Court. They should be accessible to the different levels of the legal authorities and all that the court has been developing in its precedents and jurisprudence. Thank you very much, Dr. Gomez. Dr. Patricia Perez. Thank you very much, Liliana.
Thank you. As other candidates were mentioning, I think it is important to talk about how the court spreads its work. In my opinion, in order to have accessibility, we need to spread the word on our website with everything done by the court. We also need audio guides for people with disabilities. We need accessibility for these people. There are important efforts being made to foster this kind of access. On the website, we also have a link with case law and reports, for example, with the one from 2019. We have direct expert opinions. We have opinions from human rights defenders. We have journalists. We have case law journals. We have a lot of information regarding the court in each article, including with collaboration agreements between universities and other centers for COVID-19, for human rights, and for other things. We also have social media. In social media, we have press releases and information about potential training and everything else. We also see links for webinars. In this sense, this court did amazing work. I think to improve these possibilities of access, it is also possible and important to make sure that rulings by this court are available in every language at the OAS. If we want signatories to comply with these rulings, it is important to publish information about them in their languages. This is important for dialogue. And of course, this is connected to a broader goal of our institutions. Right now, for example, we translated 27 rulings into English. We should also have shorter rulings with clear jargon. This will make it easier to translate these documents, and it is important to understand that these rulings are usually going to focus on vulnerable groups and people who are going through a vulnerable situation. This has to do with the Inter-American Summit, and we say that people in a position of vulnerability have a right to be understood and to understand what is going on. That is why it is important for us to use these simple tactics. I also believe we should have training for other public servants whose work could compromise international accountability by these states. So we're talking not only about traditional public servants, but also public servants working in the prison system, healthcare workers, people working with Social Security, among others. We know that the state works through people, and these people need to be trained to work with human rights. We should also train civil society through different formats. It is important for this court, in association with other institutions, to carry out research regarding the most effective measures to protect rights. These best practices could be shared with other players for training for better compliance. Thank you. Thank you, Dr. Perez. Now we have Dr. Cesar Landa. Thank you. In a democracy, decisions have legal effect because not only do they solve controversies between parties, but we have the connection between these states and other charters. A court publishes its rulings and decisions, and it is important for this court to have the same foundation that is going to be used in press releases in different countries. However, when these decisions have interpretation effect, the court should develop a pedagogical system on how to understand these rulings. It is important to have, for example, a summarized video format explanation, not only in Spanish, but also Portuguese, French, and English, because we need to take Caribbean populations into account. We can also foster human rights and future regulations with an intergenerational pact. We need to work on international case law that should be shared and learned by international students. We should receive support from experts when preparing for these cases. We should get influencers to support us as well. With in-person hearings in San Jose, or even online meetings, which we have been using during the pandemic, it is important to use social media to call upon people to participate in these hearings. We need participation from our member state, and we need youth to be involved in it. For example, we should use influencers. The court should use more associations and more collaborations, for example, with UNESCO, working with the youth to include information about human rights in the educational system, formally and informally. We should also work on better campaigns to train journalists in these regions when it comes to spreading the word about rulings by this court. In an app, we could have not only the case law that has been officially approved, but summaries that allow for us to understand things that are binding. We could have a thesaurus including information about these provisional president decrees in different categories. We could have filters with reach and limits and vote like LGBTIQ, women, Black populations, indigenous populations, etc. We need to make sure we have access to this case law for these proceedings. This information could be registered and we could be able to access it automatically. Summaries. It is important for us to get access to this information. We should get access to hyperlinks so that we have broad, deep training. It is also important to make sure we help the environment by avoiding printing these rulings. Thank you. Thank you, Dr. Linda. And thank you to everyone for your answers. We now go to question number 4, which will be moderated by our colleague, Gina Romero from Redlad. Thank you very much, Liliana. Thank you, dear candidates. Good afternoon. Now we'll have questions from the audience sent upon the registration. We have chosen 2 that represent recurring themes raised in the questions we received. After our event, we will send the complete list of questions sent by the audience to all our candidates. They were received by our organizing organizations. Each candidate may answer 1 or both questions within 5 minutes. Please use this time to also share any final thoughts you may wish to share with the audience. This will be our order for this section. We have Cesar Lenda, Patricia Perez, Veronica Gomez, Rodrigo, and then Nancy Hernandez. These are our 2 questions. Number 1, at the level of the Inter-American system, what are the challenges related to IACHRs? My second question is, in your opinion, what are the biggest challenges that we face here? And how would you make it better? I would now like to hand it over to Mr. Cesar Lenda. Thank you for your questions. I believe that human rights should not be taken into account as civil and political rights. Of course, we need to think about states as dictatorships and democracies and classic rights, but human beings have this universal dimension, not only politically and civilly, but also socially and economically. We should also think about the development of political rights. Article 26 of the American Convention, talking about progressive development, is an article that is really prominent and that people have been trying to resume in the past few decades progressively, so that first we understand that human rights could be collective rights. Of course, we're also thinking about populations that have been discriminated against historically. In the case of indigenous populations and other groups that have been discriminated against historically, we need to acknowledge that the rights to education, healthcare, food, and also the environment, and of course the right to labor, are key elements that are going to allow for dignified lives. We have cultural, social, economic, and other rights, social political rights as well. So the Inter-American Court of Human Rights, with this very dynamic approach, has certainly pushed the conversation forward and furthered this dialogue with a few states. This is also related to legitimacy, but it's also related to character and justice. Oftentimes, states feel like many of their rulings could offer reparation, not only individually speaking, but structurally speaking as well. These rights are progressive, not regressive, and this will allow for the Inter-American Court to keep on expanding these rights, which regionally and internationally add up. For example, the rights to food and the rights to decent housing. And this is not utopia. This won't be reduced to only a design of case law. We need to think about reality, and we need to think about conversations between states. We need to see how the court is going to tackle these cases or these proceedings that have to do with public policies. With the pandemic, we truly saw that this model is going through a crisis. So not only do we have legal decisions that could lead to improvements in the challenges presented by this court, but there's planning in the medium to long term as well. We see a design of these jurisdictional policies. The court can plan for it because its challenges are not only for processes and quantitative measures, but also qualitative measures. They need to understand what to tackle and how to do it. In Latin America right now, we face problems related not only to healthcare, but also to democracies, related to public policies. For example, we have a conversation about the known re-election of candidates. This is something that this court could develop. I think we could have a think tank to come up with the categories and tools for decision-making when facing big problems in these states. This could be applied individually or collectively. So I believe this court could have an opportunity to change through its judges. I think it is important to think about the rights and needs of our populations and to use conventional and legal norms to improve and provide our whole region with well-being. Thank you, candidate Landa. They asked me to repeat the questions. The first is, at the level of the Inter-American system, what are the challenges regarding ESCRs? So think about the case law for the court. The second question is, what are the biggest challenges for the court, and what would you suggest to overcome them? Now we're going to hear candidate Patricia Perez. Thank you. Thank you very much, Gina. Let me start off by saying that this system as a whole, of course, presents a number of challenges. We have more specific challenges, and we have other matters as procedural delays, which we could reduce by working in a coordinated way. We have many challenges here, but let me delve into one of them, universalization. Whatever efforts we may make will be in vain if 1/3 of the countries in the OAS are not in the Inter-American Commission. So this is a weakness. This means that it is important to ratify these initiatives. And why is this not happening? I think this has to do with something we've noticed and we've emphasized here. We see countries that have not ratified the competence of our court, which are Anglo-Saxon countries in the Caribbean. So we have this split, and the court has no jurisdiction over these countries. That is why, as I was saying earlier, I think it is important to translate these rulings, and we need to offer training with more accessible resources, with immediate translation and summarized versions, with the same legal rigor. When it comes to training as well, as we were saying before, lawyers from the part of the Caribbean that speaks this language. I think this is key. We should make an effort in this sense. I think our initiatives won't be fulfilled if we're unable to include Caribbean countries under our jurisdiction. There's something else that I would like to say in my last couple of minutes. I would like to reflect on the importance of building spaces to listen to people. We need to have legitimate rules for sure, and this is something the court has. But we need other tools as well, and we need to have legitimate contributions, sociologically speaking, as well. People need to feel like justice is being made. And I think we need to foster these spaces for inclusion and for listening to people. This is paramount. I connected this to my personal experience, and I think it is important to mention this both theoretically because of my master's and my PhD in constitutional rights, but also practically speaking. I worked at the Department of Justice. I worked with the evaluation of public policies, and I have my personal experience. And I've seen firsthand that it's really, really important to hear people out. We need to find better solutions, more inclusive solutions, and we need to tackle this together. That is why I believe in building something together with a human rights culture to make sure everyone works collaboratively.
Thank you very much. I now give the floor to candidate Veronica Gomez. Thank you very much. I think that during this hour or hour and a half, we've been speaking about the main challenges of the court, ranging all the way from, I wouldn't say newest topics, but holistic approaches, those that bring together protecting a healthy environment together with sustainable development and the well-being of our communities, as well as with the future of our societies and our children. All of these topics are completely intertwined. The relationship between private actors that are now more powerful than some of the states in our region, and the role they play considering the environment and vis-a-vis social, economical, and cultural rights. At a time of change like this one we're going through, we feel that international rights and international human rights are going through a moment of change. We will need to support a kind of development that will lead us to find answers to all of these problems and issues. Communication, how the court approaches the victims of civil society and states, which are still the main supporters of international rights. And these are subjects that are specified in the Inter-American Convention and other treaties, and they're essential for promoting and developing our standards. All of these topics are intertwined. Compliance of court rulings and other decisions is related to the legitimacy of this court in a very definitive way. So I think that we have already spoken about the main challenges, the classic challenges all courts face, this one and others, and how we envisage the future and how to consider them in a holistic and inclusive way that covers all states and all communities in our region. This is the main challenge. I personally believe that the next few years will be key. The next 5 to 10 years will be decisive in this regard. And I am very happy to hear the presentations of the other men and women candidates to the Inter-American Court and the high degree of coherence and consistency in their speech. I think that this is very valuable and very encouraging. What I have to offer from my part is many years of experience working with different sectors and industries in our region, working with international agencies, the state, academia, and also a very strong tie with social society. So this is the kind of input I would like to bring, the contribution I would like to make to the Inter-American Court of Human Rights and what it may provide to the peoples of our region as a just and impartial instance of interpretation of the Inter-American Convention, and also as a stance that allow us to achieve the legal safety that we can offer to our states, communities, and inhabitants. Thank you very much. Thank you very much, candidate Gomez. Candidate Rodrigo Mordovich has the floor. I would like to once again compliment all of those who are attending this event, the moderators, the organizers, and my fellow candidates to this court. I'd like to thank you for this opportunity of presenting here my candidacy to this event and the opportunity to listen to my colleagues. As Ms. Gomez has said, it is very encouraging to see the degree of consistency there is. This is very encouraging. I've always tried to build a campaign based in wide-ranging dialogue. I think that this is a precious opportunity. And I think that these two questions that were asked summarize to a large extent everything that was discussed during this 1.5 hours. We talked about the main challenges, not just referring to the existence of the Inter-American Court in the next steps, but also how to handle the correct interpretation of Article 26 of the Inter-American Human Rights Convention. I think that beyond everything that was said, that is improvement, ruling compliance, and deal with new needs and wishes and rights at a world level and to better integrate the Inter-American Court, not only in the Inter-American system, but also the international system of debating human rights. I think that there are three main axes that always have to be discussed. The first one is extremely important. I had an opportunity to mention in one of my previous answers. It is to decrease this unnecessary distance between courts and countries. This can also be done while respecting peculiarities of legal systems in countries. And I think that we should intensify the presence of the court in its dialogue with the states, especially those where the notoriety of the court is not so significant. The second axis in facing the main challenges in the court in answering to the question, it is reproducing the case law of this court and making it more widely acknowledged. I think that this will be very important to make the court better known, and so that its jurisprudence can be more often resorted to, not only in concrete cases, but also institutionally and in the educational realm. The third axis, which I have not mentioned before, which is extremely important in my view, is perfecting the in-house institutional dialogue between the court and countries, victims, and all of the actors in the Inter-American human rights system. I think that permanent open communication amongst all actors will allow us to properly face all of the main hurdles, which are not isolated, but rather shared by all of those who live in the Inter-American human rights system. And finally, going into the first question that was asked, and I mentioned this in my first answer, the importance of giving dialogic and progressive interpretations based on everything that the court has produced regarding the Article 26 of the convention. I must mention in my answer the challenges created by the COVID pandemic. I believe that inevitably this will have a consequence on the court rulings in the next few years, and it will call for a special preparation of the court. I think that the court has proven that it is able to adapt, evolve, and deal with local factors. The relevant rulings that are paradigm rights of fighting racism and many others, they all go to prove not just the importance, but the currency of this dialogue. And I think that the dialogue has to be fostered and has to be progressive also. Thank you very much. Thank you very much, candidate. And to conclude, candidate Nancy Hernandez has the floor. Thank you very much. It is difficult to summarize the number of challenges that the Inter-American Court faces, some of the old challenges and many new ones. And maybe this is the greatest challenge we'll have to face over the past 40 years. Much has been said, but fully compliance with the rulings is one of the major challenges of the Inter-American Court, to keep the right balance in the Inter-American system by assuring full participation of victims in harmony with the rights of parties. Gender parity has to be enforced. Education of its judges, strengthening the autonomy of the court, because there's a base of confidence that has to be strengthened. And this is why a priority is strengthening the independence of the court. There has to be trust in justice. And in this scenario of a crisis of the rule of law, it is very important to strengthen dialogue. Lastly, other candidates have made reference to several challenges, all of which I share. And I would like to make a final observation to all of you. Currently, it seems that everything that we have progressed in terms of democracy and human rights is at stake. There's also the added challenge of climate change and others. The task ahead is for a titan, and I see no other pathway than that of respecting and having equality and justice. People have an expectation of well-being that is not satisfied just by economic indicators. Only by respecting human rights and dignity can we minimize the challenges to democracy and fill in the gaps in society which challenge to force this into a setback. So much effort has been put in building this, and this calls for experience and commitment. But I think that that civil society is a very important element here. This competition reinforces the commitment with the inter-American system, with a project that has changed the lives of millions of people and that have helped us to be the best version of ourselves that we can be in a democracy, and to have the faith that we will be able to solve challenges ahead. I have been with committed candidates, which is a great honor to me. As you can see from my CV, my commitment is with a justice that helps us strengthen democracy and freedom, a justice that is independent, impartial, with ethical standards, that is more inclusive and present, and also more transparent. This is why I wish to have this position in the Inter-American Court. I don't have all of the answers, but I want to search for them in good faith and with all the strengths I have. Thank you very much. Thank you very much to the women and men candidates for their participation and answers. This has been an excellent dialogue and has strengthened. It has been a very important dialogue that complements in an excellent way their presentations before the OAS Permanent Council and strengthens the exchange with civil society in the region. I want to remind all people who accompany us in this event that it has been recorded and will be available on social media and of the organizing